Welcome everyone here on Zoom, but also live on Facebook. Today's class is the fourth session of Halakhah for the Ages, reading Responsa from a Bygone era with Dr. Rachel Furst. Just a reminder that those who are watching us live on Facebook can engage as a comment. You can ask questions as a comment, and I can relay them to Rachel. And just a few words about the class. Halakhic Responsa provides a window into the minds of legal scholars and decisors, and also into the social, political, and religious fabric of the societies they serve. In this course, we study a sampling of such texts from medieval Europe on topics ranging from organized crime to material conflict and interfaith cooperation. We examine these pre-modern rabbinic rulings with an eye to their legal significance and creativity, as well as to their value as source of Jewish history. Class discussions in this class address fundamental questions about the evolving and contingent nature of Halakhah and the role of scholars and lay people in its development and dissemination. And with that, I'll turn this to Rachel, and I'll let a few people in. Hello, welcome.
Okay, great. Thank you very much for that introduction. Those of you who have been with us for the past few weeks know that we're already well into our study of the medieval responsa that are going to be the focus of the remainder of this course, particularly the medieval responsa from the world of Ashkenaz, that is from the medieval German-speaking lands, medieval Northern and Central Europe. The past 2 weeks, we examined responsa that dealt with kind of juicy topics. They were both adultery cases. The one last week was particularly focused on defamation, the wife's claim that her husband had defamed her in insinuating that she had committed adultery. And these responsa gave us, among other things, an opportunity to examine the ways in which responsa got written in medieval Ashkenaz, in particular, the relationship between local batei din, local Jewish courts, and well-known halachic authorities who were sometimes consulted by those courts when they didn't exactly know how to deal with a particular legal suit or a particular dispute that came before them in court. And the respondents, these halachic authorities, would weigh in the writing by means of writing a responsum that would presumably have been considered as a piece of legal evidence or as a legal opinion that the court may have taken into consideration, although, as I've mentioned in the past, we don't usually know exactly how and whether the court ruled in accordance with the halachic authority they consulted. And this has to do with the documentation that we have or that we lack from the medieval period. We don't have regular court records. And as a matter of fact, the responsa literature itself, as I've mentioned in previous weeks, serves as one of the primary repositories for the court records that we do have from the medieval period, for most of the information that we know about the ways in which Jewish courts operated. Jewish courts being one of really the building blocks of the Jewish communities of the medieval period's autonomy, their rights to jurisdiction, their rights to self regulation. This week, we are going to be continuing, of course, in our study of the medieval Ashkenazi responsa, but we're going to be taking a little bit of a step aside. We're going to be leaving some of these more juicy interpersonal disputes behind for the moment, although we will get back to them. And we're going to be looking at responsa on a topic that is seemingly a little bit more mundane, quotidian, and that has to do with neighborly relations. Now, neighborly relations can also be a point of major friction, as we're going to see, and thus the source of many lawsuits that similarly generated the writing of Responsa. In particular, what we're going to be examining today are cases in which there were neighborly disputes between two Jews in the cities of the medieval German Empire that the Ashkenazi Jews inhabited, but neighborly disputes between Jews that involved Christians as well. And not only involved Christians, but also, therefore, involved Christian law. And so this is going to be also an opportunity to examine the ways in which the Responsa speak to the embeddedness of Jews and of Jewish law in a broader Christian majority culture, and specifically in a Christian majority legal system. So we're going to be thinking about the extent to which Jews were aware of and operated in accordance with local legal norms. How much did they know about Halakhah, and how much do they know about the local law? And I think we may see some perhaps surprising things. Okay, so with that, and with no further ado, what I'd like to begin with today, as is our norm, is the Halachic Responsa themselves. And I'm going to share on my screen now the handout that I believe was sent out to all of you. For those who do not have it, it is now in the chat as well, so that you can follow along with the main halachic texts that we're going to be examining together. Okay, you should see this in front of you now. This is what the sheet looks like. We're actually going to be starting today, not with source number 1, which is one of the responsa we're going to be examining, or maybe the primary responsum we're going to be examining. I'm going to scroll down to the second page of this handout. And we're going to be beginning today with the responsum that is labeled number 2. You can see it on the screen, and you should be able to find it on your handouts on page 2. You will see, by virtue of its title, that this is a responsum that was collected in one of the collections of Rabbi Meir of Rothenburg. We've met this important halachic scholar in previous weeks. And indeed, the two main halachic responsa we're going to be examining today were also authored by Rabbi Meir. Just to remind you, Rabbi Meir ben Baruch of Rothenburg, we know that he died in 1293, so towards the very end of the 13th century. And we also know that he was imprisoned in 1286. So the last several years of his life, whereas we do know that he was in correspondence with some of his students and did issue some halachic opinions, the general assumption among scholars is that most of his scholarly activity occurred before 1286. So while we can't exactly date this particular responsum, nor can we precisely locate it. And in that respect, this responsum is somewhat different than the two we've seen in the 2 previous weeks that did contain details that allowed us to both date and locate the halachic opinion. While we can't do that so precisely with this particular piece, we can, I think, assume that it was written probably in the 1270s or the 1280s, before Rabbi Meir was incarcerated, possibly in the 1260s, because he was already active as a halachic authority then. But we're talking about basically the middle, but really the second half of the 13th century, those decades, 1260s, 1270s, 1280s. Okay, now, you can see from the very opening lines of this responsum, source number 2, that this responsum does not contain the original question that was posed to Rabbi Meir, as in our example from 2 weeks ago, nor does it even contain a summary of the question that was posed to him, as in our responsum from last week. Here, all that we really have is Rabbi Meir's response, and it is left to us as readers of this responsum to reconstruct what the question was. Because this is only the opening piece, I'm going to kind of spare you the work. I will share with you what I have reconstructed as the question based on a close reading of this responsum. And then we're going to look at the answer. This will be a prelude to looking more closely and really doing the reconstructive work with the second responsum. So apparently, this particular responsum by Rabbi Meir of Rodenburg was written in response to a local Jewish court. Again, we don't know from precisely where, but somewhere in the medieval German Empire. Those were most of the cases that came to Rabbi Meir. This particular dispute between two Jewish neighbors came to a local court. The local court did not know how to contend with it, and we'll see momentarily why. And so they consulted with Rabbi Meir, and Rabbi Meir responded to them. And it seems that the dispute was as follows. A man who was called Reuben, a Jewish man called Reuben, and again, I will reiterate what I've said in previous weeks, that most of the names in these responsa, particularly when they're names like Reuben, Simeon, Leah, Rachel, right? These are names that are stock names. That is, these were in all likelihood not the names of the original litigants, of the original individuals involved, but rather, again, stock names that possibly the original judges substituted in an attempt to preserve the anonymity of the litigants, and maybe these were names that were assigned by later copyists. It's possible that the original judges did use original names, but that later copyists who were really interested in these responsa not as historical records, which is kind of unfortunate for those of us who do want to use them as historical records. They were interested in preserving these responsa for their Halakhic precedent. And if you're interested in the Halakhic precedent and not in the historical nature of such responsa, then you don't really care so much about the individual's names. It's important to present their claims. It's important to record the responses to them, the Halachic authorities' responses, but it's not so important to preserve their names. And so it's also possible, as I said, that later scholars and copyists were the ones who substituted the real names for these Reuben, Simeon designations. In any event, back to our case, right? So we have a Jewish man named Reuben who opened windows in his home, his house, that overlooked his Christian neighbor's property. Now, here I want to pause for a moment. We're going to talk about this much more, but already at the outset, I want to note that Jews in the medieval period, particularly Jews in medieval Ashkenaz, and again, I want to remind you that when I use the term medieval can be used in different senses, but when I use that term, I'm referring to a period of time between roughly 1000 and 1500, okay? Jews during the vast majority of that period, certainly up until the 15th century, in the medieval German Empire, lived primarily in urban areas, in the cities of the medieval German Empire, where they were not confined to ghettos. And this is an important point that I wish to underscore, because I think many people have the misperception that medieval Jews lived in ghettos being sort of closed, sealed, segregated areas that they were forced to live in apart from the remainder of the population. And that is in fact not the case. The ghetto is an early modern phenomenon, a phenomenon from the 15th century and on. But in these earlier centuries that we're discussing, the 11th, the 12th, the 13th, and even well into the 14th centuries, Jews lived side by side in these urban centers, side by side, sometimes even in the same structures as their Christian neighbors. Now, it is true that oftentimes Jews in these urban areas lived in close proximity to one another. right? There were oftentimes Jewish areas or Jewish quarters where the Jews tended to congregate, tended to buy homes near one another so that they could use common institutional structures like the synagogue, like the mikveh, and so that they could, in some cases, erect things like a Shabbat Eruv, a Shabbat perimeter. But that was by choice. That was not by external force. And even when they clustered together, excuse me, as I said just a moment ago, they almost always also had Christian neighbors. In a few cases during this period, there were gates to the Jewish neighborhood that could be closed, but they were always closed by the Jews themselves. It was a voluntary decision on the part of the Jews when that was the case, and that was not the case in the majority of cities and towns during this period. And our responsa that we're going to see today are very clear evidence of that fact, right? Because again, we have a Jew named Reuben, or Jew called Reuben at least, who opened windows that directly looked into the property of his Christian neighbor, right? So they were in very close proximity to one another. Now, at some point, that Christian neighbor sold his building, his home, to another Jew who is called here Simeon. Simeon did not like his neighbor Reuben looking into his property or into his home. It disturbed him that Reuben had these windows with direct line of vision into this new home that he had purchased. And so he brought Reuben to a Jewish court and demanded that Reuben close up the openings, close up those windows. Reuben refused. He refused to close his windows because he claimed that he had pre-established rights to those windows, what we would call in Jewish law a chazakah. What we're about to read is Rabbi Meir's response to this dispute, right? Again, Reuben is the original Jewish property owner. Simeon is the new neighbor who has purchased from the Christian. Simeon is demanding that Reuben close the windows. Reuben says, no way, I have the rights to them. Okay? And here, let's begin with the text. Rabbi Meir says, I will respond briefly. It seems to me that the law is with Simeon and not with Reuben, who opened his windows looking onto the land abutting his when it still belonged to the non-Jew. Right, so he makes very clear from the outset, Rabbi Meir, that he's ruling in favor of the new Jewish neighbor, Simeon, the one who purchased the property from the Christian, and not with Reuben, the original Jewish owner. Why? Rabbi Meir goes on to say, he, and this is a reference to Reuben, the original owner, does not claim that he purchased it, meaning the light and air rights, from the non-Jew. Rather, he wishes to acquire the rights to the light from the lands abutting his on the basis of the fact that no one protested his actions in opening the windows. Right, so apparently Reuben was claiming, I have rights, I have pre-established rights to these windows because I opened them a while ago and nobody ever told me it bothered them, right? Nobody being his former Christian neighbor, right? Nobody ever protested. And so I've had these windows for years, and now by definition, I have acquired a chazakah, I have established the right to them, right? Rabbi Meir says that doesn't work here. Moreover, he has not maintained his windows for 3 years as recognized by Jewish law. Thus, he does not have an established precedent with legally valid claim, nor even one without a legally valid claim, right? He has no right. His whole claim, Reuben's claim to having a pre-established right, is unacceptable, does not work. Nevertheless, he tells Simeon, who purchased the property from the non-Jew, to distance his building from his windows, for he has acquired the rights to the light, right? So Reuben is insisting that Simeon move away because the rights are his. But according to all that we have described, he has not acquired them, not according to Jewish law, and not according to their law, by which he means German/Christian law. And I want to pause here for a moment, because this, to my mind, is a really significant statement, right? Rabbi Meir is making his argument on the basis of Jewish law, but he's also making his argument on the basis of local law. Okay, hold that thought and let's continue. For according to their law, that is German law, he would not acquire them, that is the rights, even with an established precedent of 3 years and even with a legally valid claim, right? That might work according to Jewish law, but that does not work according to German law. For according to their law, and again, their law is Rabbi Meir's term, right, for the non-Jewish law. According to their law, the non-Jew could have built a wall opposite him, that is to block the windows, at any point, unless Reuben has witnesses that he formally purchased the rights to the light. And according to our law being, of course, Halakhah or Jewish law, he has not acquired the rights until he has maintained the windows for 3 years and established ownership with a specifically legally valid claim. Neither of which are true in this case, says Rabbi Meir. So what did the non-Jew sell to Simeon, right? When Simeon purchased the property from this former Christian neighbor, what did he acquire? All the rights that he had regarding his property. And so just like the non-Jew could have built a wall and thereby darkened Reuben's windows, Simeon can now do the same. However, he cannot force Reuben to make the effort to block up the windows himself, although he could have done so if Reuben had purchased the property from a fellow Jew, as we learned from the end of the Talmudic chapter, Chazkat HaBatim. But here, where the second Jew is a Jew who purchases from a non-Jew, as it says in chapter Chazkat HaBatim, that a Jew who purchases from a non-Jew is like the non-Jew. And the non-Jew who sold to him would not have been able to force Reuben to make the effort himself to block them up, for it is not so according to their law, again, German or Christian law. Rather, if the non-Jew wants, he builds a wall opposite him. Behold, he, right, that is Simeon the purchaser, is like the non-Jew and no more. So let's pause for just a moment here. We're going to be unpacking all of these concepts over the course of our class today. But I'll just point out right here that Rabbi Meir's argument is that when Simeon the Jew purchased property from this unnamed Christian, what he acquired were all the rights that that Christian had, right? And he uses a Talmudic source to prove this, right? He quotes Tractate Baba Batra, Perek Chazkat HaBatim, where it says that if a Jew purchases from a non-Jew, the Jew is like the non-Jew, meaning he has all the rights of the non-Jew. Now, what were the Christian's rights when he was the owner of the property? Well, the Christian's rights were determined by local law, by local Christian or German law. And according to German law, you can do whatever you want within your own property. We're going to see in just a moment that is a significant difference between German law of the medieval period and Jewish law, right? German law allowed people to do whatever they wanted in their own property. And so therefore, Rabbi Meir concludes that Simeon, who has now acquired the rights of the Christian, can do just like the Christian would have, meaning he can do whatever he wants within his own property. He can't, right? He says the law is with Simeon, but that doesn't mean that Simeon can make Reuben close his windows. What he can do is he can build a wall at the edge of his property to prevent Reuben from being able to see into his property. That's presumably what disturbed him all along. In doing so, he may well block Reuben's light, but that's okay, because he has the rights that the former Christian owner had, and according to local Christian law, that is perfectly fine. You can do whatever you want within your own property, regardless of its implication for your neighbors. And Rabbi Meir writes here, in conclusion, the law is with Simeon, and if Simeon wishes, he may build a wall opposite Reuben's windows and block them. And he signs, Meir ben Baruch, may he merit eternal life. Okay. This is our, as I said, first responsa. We're going to be looking at the second one, which is a similar case, but where Rabbi Meir adds additional details, demonstrating his familiarity with local law and kind of deepening his argument concerning the implications and the relevance of local law for this ostensibly inner Jewish conflict. But before we do so, I want to take a step back and appreciate for a moment what Jewish law, what Halakhah actually says in a case like this. What are the different factors that Rabbi Meir is weighing and negotiating and playing with here, right? What does Jewish law say? And what did local German Christian law say? And what is he exactly referring to when he keeps referencing our law, meaning Halakhah, versus their law, or again, the local norms? In order to do this, I'm going to switch screen shares. I'm going to open my PowerPoint, but I want to take this pause here for just a moment. If anyone has questions right here, please feel free to jump in. And I just, again, want to reiterate what I've said in previous weeks, that if anybody has questions as I'm going along, you can really feel free to ask them, and I'll answer them as I can. Okay, so as I'm doing the switching my screen share, you can think about whether there is anything you'd like to ask. Oops, excuse me.
So just a comment, the classic
Yes,
case
please.
of Baba Batra is, I think, referred to as Hezek Rihiyah, and that
Yes.
I think most of the—
Yes, that's exactly what we're going to see right now. But what did you want to say about that?
No, just like the upshots usually are that it constitutes an actual set of damages that require amelioration or reparation.
Yes, thank you for pointing that out. We're going to see, as I said, we're going to take a look at what Jewish law would say on this matter. What is the halachic position that Rabbi Meir is negotiating? So first of all, here, I just want to, again, this is our map of the medieval German Empire, give or take. We know that this case happened somewhere here, but as I said, we can't really locate it any more precisely. Again, to remind you in terms of the chronology, you can see the death of Rabbi Meir ben Baruch in 1293. This Responsa was obviously written in the decades prior to that, when Meir was already the major authority in the region. Okay, here we go. Let's take a look. You just referenced this Mishnah or one of these Mishnayot in Tractate Baba Batra. The Mishnah says, and again, just sort of as a broad statement, I would say, it is very clear that Halakhah, that Jewish law, starting with the Mishnah, and through the Talmudim and through, according to all the medieval authorities, Jewish law regulates building practices, right? Jewish law has a lot to say about neighborly relations in general. It regulates neighborly relations in various kinds of ways, including building practices. And again, because we're talking about windows, I want to focus in on the way that Jewish law deals with that particular issue. And by the way, I should note that windows were a source of, if again, the use of Responsa are any evidence, and also archival materials that we're going to be getting to later are any evidence, windows were a source of major contention between people in what were often very crowded, dense, urban areas. We're going to see some pictures of that, and I will have a little bit more to say. But let's take a quick look at this Mishnah. So the Mishnah says, in a courtyard which he shares with others, a person should not open a door facing another person's door, nor a window facing another person's window. If it is small, meaning if he has a window and it's small, he should not enlarge it, and he should not turn one into two. Right now here, the Mishnah does not explain why, right? It just says that you're not allowed to open either a window or a door directly facing your neighbor's window or door. On the side of a public thoroughfare, however, right, if these windows or doors are not facing a common courtyard with your neighbors, but they're facing a public thoroughfare, then he may make a door facing another person's door and a window facing another person's window. And if it's small, he may enlarge it, or he may make two out of one, right? So the Mishnah here seems to be making a distinction, first and foremost, making a distinction between what you're allowed to do in a shared courtyard between neighbors and what you're allowed to do facing a public thoroughfare. Again, the Mishnah does not provide the logic here, but presumably, if your doors and windows are facing a public thoroughfare, then, again, even if your neighbor has doors and windows facing a public thoroughfare, presumably they're kind of anyway subject to all kinds of people who go through the public thoroughfare, either looking in or disturbing their light, their sound, etc. Right? But again, the Mishnah itself does not provide the logic. The Babylonian Talmud, in its discussion on a related Mishnah, states as follows, and I think this explains some of the logic of the Mishnah that we just saw. If there are windows in the neighbor's wall, he, meaning the one who wants to open a window, must leave a clear space of 4 cubits, whether above or below or opposite. Right? That's a related Mishnah. And in a Breita commenting on this, it is stated that a space must be left above so that he should not be able to peep into the other one's room, and below so that he should not be able to stand on tiptoe and look in, and opposite so that he should not take away his light. Right? And just to sort of, again, the Gemara here has extensive pages-long discussions about these principles and about what Justin, just mentioned, this concept of hezek riyah, this idea that you can cause damage to someone through looking at them, through what we would call today invading their privacy, right? This idea that people have a right, neighbors, people in their homes have a right to privacy within their homes. And we regulate their neighbors' construction of windows and doorways in order to protect the privacy of the one who established them first. We don't want neighbors staring into each other's homes. I say this as I'm looking out a window right now where I can see pretty much directly into my neighbor's home. So that's, again, in urban or even suburban environments like I live in, not always the case, the reality today, but this is what the Halakhah requires. At the same time, the Halakhah also understands and recognizes that individuals have a right to light and air that windows provide. And these two things can sometimes come into conflict, right? In other words, one person's light and air can sometimes come at the expense of another person's privacy. And it's that friction which these Mishnayot and the various, again, pages in the Babylonian Talmud and other Talmudic texts that discuss this are trying to negotiate and work out. Again, the point is that Halakhah definitely has rules and regulations governing this facet of neighborly relations. And as I mentioned just a moment ago, I want to just show you a few pictures from, again, these are my own personal pictures. So this is obviously what has remained today of some medieval construction. What you see here is actually from Rothenburg under Tauber. That was the town that Rabbi Meir himself inhabited for a period of his life. And one thing I want to point out here, first of all, you can see how close the buildings are together. And you can also see that during this period, windows in private residences, did not usually have glass in them. That was a luxury that maybe churches had or other public buildings had, but individual windows were usually closed with these kind of wooden shutters that you see here in the picture, which meant, and sometimes with some kind of oil paper or something like that might have covered it when the window was open. But that meant that in addition to light and air, they also let in a lot of noise, a lot of smells. And that was oftentimes also one of the points of contention between neighbors who did not like having windows facing each other across, as you can see here, sort of a very narrow courtyard between these two houses, if you can even call it that. This other example that I have from you is actually, it's from England. It's not from the German Empire, but it's from the same time period, more or less. This is from the city of York. And here I just think it's very striking. It was striking to me, at least when I was there, that you can really see how these medieval houses were constructed so close to each other, sometimes stories upon stories that got increasingly close to one another. And I think it can allow us to begin to appreciate why these conflicts arose and how significant they might have been between neighbors, be they, again, two Jews or a Christian and a Jew or two Christians, right? Again, I do want to underscore here that just because in this particular case and the other case that we're going to see today, the conflict arose once a fellow Jew bought the neighboring house, that is not to suggest that these issues were only issues for Jews or between Jews. There is plenty of evidence that medieval Christians in these towns were locked in conflict with one another as well as with their Jewish neighbors. They also cared very much about light, air, privacy, etc. Now, I want to again, because Rabbi Meir kept referencing our law, Halakhah, versus their law, that is the German Christians' law, I want to take a moment to clarify what the difference was. If just as just a moment ago we said, Jewish law really provided, rules and regulations for how to negotiate these conflicts between neighbors. In German law of the time, these rights, that is, again, the rights to light, to air, to privacy, were for the most part, not regulated on a general universal basis. That is to say, there were not general rules and regulations that applied across the board to all neighbors in the way that Halakhah provided. Again, as I said just a moment ago, that does not mean that they did not recognize or care about these rights, but the way that medieval German law regulated these rights was on an individual contractual basis. Meaning, if I, as a homeowner, wanted to acquire or to assert my rights to the windows that I had opened, or on the flip side, my right to privacy that would prevent my neighbor from opening windows looking into my property, it had to be done on a contractual basis, meaning I had to write a contract. I had to go to court or go to a notary and write a contract with my neighbor, spelling out the fact that we had come to an agreement and I had acquired those rights. And sometimes these kinds of contracts were independent contracts between neighbors, but very often they were written up in the context of house sales. And I want to take a look just so that you have, again, an understanding of what Rabbi Meir was referring to when he kept saying their law. I want to take a look at one example of this. It's from 1375, as you can see here. The original text is in medieval German. And this is let's read the English translation to get an appreciation for this. And by the way, as you're about to see, this particular house sale involved a Jew. It was issued by the Council of Frankfurt in the context of a house sale. We, the mayor, judges, and Council of Frankfurt, officially declare with this letter that Conrad of Löwenstein, our colleague and fellow councilman, is standing in front of us and declares that he sold and handed his house and his estate, which is currently inhabited by Jocelyn of Marburg, to the Jew Fivelin of Dieburg, right? So Conrad, the Christian, sold his house to Fivelin, the Jew. With regard to the shared wall next to the well, neither neighbor should build a structure that would block the other's light. Neither Conrad nor any other owner of the stone house should open windows, lights, or doors that might disturb Fivelin or his heirs or any other owner of the aforementioned house. Furthermore, the doors and windows currently facing towards Fivelin should be sealed up by Conrad, right? So Conrad is the one who sold the house to Fivelin. Apparently he owns the adjoining structure, the neighboring structure, right? And at the time that he sold his house to the Jew Fivelin made this contract with him, which explicitly stated that it was imperative upon Conrad to close up doors and windows facing his new home and prohibiting him and any other future owners of that neighboring home from opening doors or windows that would look into Fivelin's property, right? So this is an example of exactly what Rabbi Meir was referring to when he mentioned their law, the non-Jewish, the Christian, local German law, right? It was regulated not by general principles the way Halakhah provided, but rather by these kinds of contractual agreements. Now, Rabbi Meir seems to have known that very well, right? He seems to have known pretty intimately the way in which his and the disputants' Christian neighbors regulated these issues. And I want to show you that by looking at our next responsum, right, source number 1 on our page, where we're going to see Rabbi Meir making explicit reference to these kinds of contracts. Just for a moment before we do that, I want to, so just to avoid having to jump back and forth between the screens, I want to show you here just briefly, this is an arbitration agreement, also, as you can see, from the end of the 14th century between a Jew and a Christian religious order, also pertaining to windows. I just want you to get a sense of what some of, last week I showed you what one of the Responsa manuscripts looks like. This is what some of these individual contracts drawn up having to do with windows, with light and air and privacy rights might have looked like. And I also want to show you here that Jews also drew up contracts that oftentimes also reference things like light and window and privacy rights in a way that was very markedly similar to their Christian neighbors, despite the fact that
It looks like she might have lost connections. Let me, sorry about the inconvenience, everyone. Oh, there she is. Okay, perfect. Okay, just unmute Rachel. Rachel, just unmute first.
Thank you. Okay, I guess we lost one another. I'm sorry about that. I don't know exactly when it happened, but I think, wait, first of all, I see that I have to reshare my screen.
It was only
right?
about
Is
a
that
minute.
correct?
Yeah.
Okay, so let me just get my screen back up there. What I was saying, I think, as we got cut off, is that Jews, and this is an example of a, you can see that it's in Hebrew, right? Even if you can't read all the details, you can see that it's in Hebrew. This is a deed for a house sale in 1281, written by Jews, between two Jews, that sounds actually very similar to the type of Christian contracts that we saw just before. That is, despite the fact that Halakhah provides these general regulations, many medieval German Jews chose to write contracts more in the style of their Christian neighbors. And we can think a little bit in a moment about why. The final thing that I want to show you here, this is a little note that was kind of included on the backside of a document. You can see it's, we can debate about whether this is Judeo-German or whether this is Yiddish, but it says, über die Licht und Fenster von der näheren satteren Hus mit darum le Beis Knesses, right? And what this means basically is this, it's a little note on the backside of a document that was used for archival purposes. It was kind of like, it was to enable the owner of this document to quickly find it in his files. And it explains that this particular document was about the light and the window from a particular house that was located to the south of the synagogue, right? Just to demonstrate again that Jews were very concerned about these things and also kept documents much as their Christian neighbors did. Okay, again, as I said just a moment ago, I'm going to stop this share and I'm going to get back to our text, but I think that we might have a question at this is a good time for that. If anybody does, they're very welcome.
Do we have any?
Yes, please.
Do we have any idea how many people were literate at that time? That the
Are you
owner
talking about Jews or Christians?
Both. It's like the owner here. Excuse me. The owner here, you said, wants to keep a file on it. So this owner could, but would other Christian, leaders, owners have been able to, or would they have had somebody write for them?
So this is a great question. I'm going to answer it briefly, although it's, again, we could talk about this for ages. First of all, these documents, whether they were the, those fancy, certainly that fancy document that you saw, that fancy Latin document, or the German documents that were issued in the German Empire at this point, they were drawn up by notaries, right? So they were not written by the individual, buyers and sellers. They were drawn up by notaries. They were sealed by authorities. And so they, in and of themselves, do not prove anybody's literacy except the notaries, right? Or the authorities who drew them up. The document like the one that we just saw from the Jewish Hebrew house sale, that was also drawn up in a Beit Din, we know in that particular case. But what I didn't point out to you is that at the bottom of that document, there were signatures, and those signatures were of various parties, which seemed to indicate that at least in the Jewish, right, Jews generally use signatures as opposed to seals, although we know that Jews had seals as well. This is, again, a different topic that is interesting, but we'll have to leave aside for right now. In any case, I would say, as a general answer to your question, we don't know exact literacy rates. The assumption is that within the Jewish community, basic literacy was probably more widespread than among Christians of the time. What exactly the extent of basic literacy was is a bit of a matter of dispute, but probably most Jewish adult males at the time knew how to sign their name. We actually do have signatures from women as well, so certainly some women knew how to, at minimum, write their names. And we know from various sources we can assume that most adult Jewish males knew how to read basic prayers, basic, Bible. Whether they understood the Hebrew is another question altogether. The extent of their literacy in the local vernacular is a separate story. But we can assume that they had basic literacy, and the extent to which that pertains to women is, again, a subject for another interesting discussion. I hope that answers your question. But basically, with regard to these documents, the documents in and of themselves, except for the signatures, don't necessarily prove anything with regards to the average person's literacy because they were drawn up by notaries or other authorities. Okay, I hope that answered your question more or less. Okay,
thank you.
Because our time is, you're welcome. Thanks for asking. Because our time is a little bit tight, I do want to move now to this other responsum by Mayor of Rotenburg. Now, we're going to see here, actually, the question is included, as well as Mayor's response. And I'm just scrolling down for just one moment to show you that the questioner signed his name in this particular case. The questioner was Rabbi Menachem ben David, who was, in fact, he's a known personality. He was a scholar who corresponded with Rabbi Meir on a variety of occasions. He seems to have been a judge on a Jewish court in Würzburg for at least some period of his life. And it's probably in that capacity that the following case came to him and that he wrote away to Rabbi Meir. So maybe this case took place in Würzburg, which was kind of like in the center south of the German Empire. To the one who has a light on him, so let's read the question, because here I think we can reconstruct the scenario, which is very similar to that first responsa, by reading the question itself. To the one who has a light on him, like Moses, peace, our teacher, Rabbi Meir, eyes of the exile. Enlighten me regarding the matter of Reuben, who had a house abutting the non-Jew. Right? So again, we're talking about a Reuben, not the same Reuben, a different individual, Jewish man, who had a house abutting that of his non-Jewish Christian neighbor, and he opened windows in it illegally. Okay? Now we're going to see that when he says illegally, it means illegally according to Halakhah, right? For the law of the non-Jews is that one may build on his own property whatever he wants, as we said before. And even if they opened windows facing him for several years, he could block them whenever he wished, for he would simply build in front of them within his own property, right? So again, as we said beforehand, Rabbi Meir was well aware of the fact that in the local legal sphere, the way that they dealt with these issues was that everybody does whatever they want on their property, right? They don't have the rules that we saw in the Mishnah or in the Gemara, right? So a neighbor could open up windows, and if his, neighbor didn't like it, he would just build a wall blocking the windows from looking into his property, right? So Reuben opened windows facing his Christian neighbor. Fine. Now the non-Jew went and sold his house to Simeon. Again, not the same Simeon, a different Simeon, okay? But another Jew, right? So now we again have Reuben and Simeon, who are now two Jewish neighbors. But in this case, the non-Jew said to Simeon at the time of the sale, "You may build in front of Reuben's windows whenever you like." And he wrote this for him in a Latin document. Now I translated this as Latin document. What it says is ktav pasul. Ktav pasul literally means an invalid document, but that was rabbinic, euphemism is not the right word, rabbinic parlance, let's say, for Latin, or possibly in this case, German, because we know that in the medieval German Empire, by this point in time, much of the official correspondence, much of the notarial work was done in German. So it's possibly Latin, possibly German. Point is, the Christian seller handed him a document that he had with the seal of the city council. Okay. And that document said, you can build in front of Reuben's windows whenever you want. In other words, think back again to that document that we saw between Conrad and Fivelin, right? The Christian owner had a document saying, I have the right to do what I want to block my neighbor's light and air. And he gave that document, he handed that document over to the Jew to whom he sold his property. And now they come to court, and Simeon says, block up the windows. And he presumably brings this document, this German or Latin document with him. In other words, Simeon is going into a Jewish court to dispute with his Jewish neighbor, but he brings into this Beit Din his, again, Latin or German document that he got from his non-Jewish seller. And he thinks that it's going to have weight in the Jewish court. And I think, again, I want to underscore that. And he says to Reuben, block up the windows. And Reuben responded, these windows were already facing the non-Jew, right? And again, he says, block up the windows, and he waves the document saying, look, right? And Reuben responded, these windows were already facing the non-Jew for more than the requisite years needed to establish a legal precedent. Again, we saw in the previous example that this was 3 years, according to Halakhah, would establish a chazakah. And Simeon responded, that precedent is no precedent. Right, because the concept of establishing a chazakah over your windows is that you built them and your neighbor said nothing for 3 years. So presumably that proves that your neighbor agreed to their existence. But Simeon said that precedent is no precedent for the reason that the non-Jew remained silent, that is, he didn't protest the windows, is because according to their law, he could wait until he wanted with his building, right? He could build whenever he wanted. They don't have a concept of chazakah. And furthermore, it was a precedent with a legally valid claim, right? And so now, instruct us, our teacher, this is Menachem Ben David speaking to Meir. He says, instruct us concerning the justice of the law, whether Reuben needs a document of legal precedent, right? So now, does that original Jewish neighbor, right, does he need his own document to establish his claim, given that he comes by force of the precedent he established with the non-Jew, right? He's claiming he established a chazakah with a non-Jewish neighbor, so does he also need a Latin or German document? And instruct us further concerning that which is written in chapter Chazkat HaBatim, right? So tell us about the non-Jewish law, tell us about the Halakhah, that Rabbi Yehuda said in the name of Samuel, the property of a non-Jew is like a wilderness. If Reuben purchased the land from a non-Jew but didn't give him the money, nor has a Latin document been written, and then Reuben plowed it in front of the witnesses, et cetera, et cetera. I'm gonna gloss over this part in the interest of time. But basically, he says that he concludes, please respond to all this and write proofs, and peace to your student, Rabbi Menachem Ben David, may he merit eternal life, right? So he's saying to Meir, what do? I have these 2 Jews who are fighting about the windows and they're bringing Latin documents into my court. I don't know what to do. Let's see what Meir says. Okay, we already know from the previous responsum that Meir is pretty familiar with these kinds of documents, with the way that local law works. So he writes as follows. This is my answer. This is Meir now. I have come briefly, though by a long road, improperly, to the lion of the pack, to the honorable, foremost, and renowned Rabbi Menachem Ben David. And again, I've said in the past, right, these kind of flowery introductions are kind of a hallmark of these medieval responsa. And I will answer you according to my humble opinion, right? And again, all these expressions of humility are from Rabbi Meir. I mean, he might have been a humble person, but he is, without question, the established, renowned authority by this point in time. So it's part of the genre. He says, I will answer you according to my humble opinion that Simeon cannot force Reuben to block up his windows, right? So the new Jewish neighbor can't force Reuben to block them up, for he's no better than anyone else who purchases from them. And in accordance with the Talmud, one who purchases from a non-Jew is like the non-Jew, right? We saw that quote beforehand as well. And because the non-Jew would not have been able to force him to block them up, for according to their law, right, according to the local law, dinehem, everyone may do in his property whatever he desires. Therefore, Simeon too, who purchased from that Christian non-Jew, is not any better. Rather, Simeon may build in his property in front of Reuben's windows and block Reuben's light, for Reuben is not claiming he acquired the light rights from the non-Jew. He's making a claim that has no legal validity and it's not worth anything, as Simeon himself claimed, right? And furthermore, it seems to me that if it was known to witnesses that Reuben did not originally have an established precedent regarding his rights to the light against the non-Jew, but after a time simply opened windows onto the non-Jew's courtyard and held onto them for 3 years and now claims that he acquired them from the non-Jew, it does not immediately become established precedent, right? Even according to Jewish law, this doesn't work. Why? For it is like the case of the household of the exilarch, and he's referring to a case in Bava Batra 36a. They do not establish presumption of ownership, right? With regards to the exilarch, this was the Jewish leader of the diaspora at the time. They do not establish presumption of ownership in our land, and we do not establish presumption of ownership in their land, since they are wealthy, right? So in other words, this whole concept of chazaka does not work with the exilarchs, that says the Gemara. Why? Because the exilarchs are wealthy and have many houses and fields and vineyards. And additionally, we rely on the fact that anytime they wish, they can just take their property back by force, and thus they do not bother to protest. So the whole concept of chazaka, again, of establishing a precedent by having opened windows and having heard no protest for the duration of at least 3 years, right? That's the concept of establishing your right by chazaka. That doesn't work according to the Gemara with the exilarch, because the exilarch, again, was the leader of the Jews in the diaspora. They could just do whatever they wanted by force when they felt like it, right? So the concept of precedent, the fact that they didn't protest for 3 years does not prove that they didn't care about the opening of the windows, because they just thought to themselves, well, whatever, it doesn't bother me right now. Whenever it starts bothering me, I'll do whatever I want because I'm the exilarch. So too, says Meir, so too here, the non-Jew did not worry, right? The non-Jew didn't bother to protest when Reuben opened up his windows, as according to their law, he knew that by local law, it does not establish a presumption of ownership. And if so, he must always warn him with a document, right? The fact that the non-Jew didn't protest proves nothing, right? It does not serve as a way for Reuben to establish a chazakah. In this case, says Meir, and this is our concluding statement here, it is the law of the land, right? This is that famous phrase, dina de malchuta, that a person does not ever establish a legal precedent regarding the rights to light, whether non-Jew to non-Jew or Jew to non-Jew. And there is no corrective other than with a document that he has acquired from the non-Jew. And in any case, the windows that are erected within his property and open to owner's lands have not bought for him the light rights in this ownerless land. Peace, Meir ben Baruch. Right? So once again, here, Meir is very consistent. He rules in accordance with he rules on behalf of the new neighbor, right? He says the new neighbor can't force the previous neighbor, Reuben, to block up his windows, but he can do whatever he wants in his own property. And Reuben has no, meaning he can build a wall that prevents Reuben from seeing into his property. Doesn't matter if that wall blocks Reuben's light. Reuben had no right to that light. The fact that he opened the windows facing his non-Jewish neighbor's property did not establish that right, because that's not the way law works in this land, right? That's not what the non-Jewish Christian original owner would have assumed to be the case. That's not the way their law works. And when the original owner was Christian, their law, local law, that is incredibly relevant. And it continues to be incredibly relevant when a Jew purchases the property from the Christian, right? Now, our time is nearly up. And what I want to underscore, what I want to leave you with as a thought, and we can return to this again in future sessions, is that we see here, first of all, Meir, the Halakhic authority, highly familiar with local law. acknowledging not only local law, but the instruments of local law, these documents, and admitting them into the Jewish courtroom and giving them weight and validity within the Jewish courtroom, and actually ruling that in certain cases between Jews, local law is more relevant than Halakhah. And again, I think it says a lot. We can learn a lot from these responsa about the reality that in which Jews lived in these urban environments. But I think we can also learn a lot about the broader legal culture that Halakhah was and within which Halakhah operated on the part of these individual litigants as far as they were concerned, right, bringing in these documents and their expectations with regards to the sort of shared nature or the embeddedness, as I said, of Halakhah in a broader legal system. But also, and this is maybe even more significant, that seems to be what Rabbi Meir of Rothenburg, the, again, supreme Halachic authority in Germany at the time, assumed as well. I'll leave you with that thought for today. If there are any questions, I'd be very happy to take them now. And if not, we can certainly continue to think about this more and work it out in the coming weeks.
Thank you.
Any questions before we close today's wonderful class? Okay, I don't see any comments on Facebook either. So thank you so much, Dr. Furst, for sharing your Torah with us today. And thank you to everyone who participated, not only here on Zoom, but also those who watch us live on Facebook. Just a reminder that this Thursday at 12:30 p.m. Eastern, we have Dr. Hanan Gafni, who will be teaching as part of the discussions on the Parashah class. And more classes and more information is available on our website, 5784.drisha.org/spring. And Lehitra for now. Bye-bye.
Bye.